Hey kids, it is me, Mrs. Donahue. Now, in the interest of giving you this very vital piece of information, but keeping us sort of moving forward and doing some of the more sort of entertaining stuff like Truman and getting to Fahrenheit 451, I am making this into just a short video reviewing the Bill of Rights. I'm actually pairing it with another video that I love. The man is, I think, clearly a middle school teacher. And the way that he goes through it, I find very memorable, but you guys often hate. Because you often hate it, and I find it funny, and I'm not there to sort of hold your hand and force you to watch it, I'm also going to do this video because some of you vaguely find me more entertaining. So this is me reviewing the Bill of Rights. One, why are we doing this? Often, a lot of times, your frustrations about the country or your deepest feelings about the country are rather embedded in several of the key Bill of Rights. Often in research paper times, we find that students can default go to one or two of these and review whether or not they are still relevant or whether they need to be updated or whether or not sort of the original idea still exists or not. Usually this is the First and Second Amendment I'm talking about with that. Those are usually the two that come up the most with students. I keep saying research paper. Declaration of Independence and Bill of Rights, believe it or not, make some key appearances on research papers more often than they don't. So I really don't like cutting them from you guys, even if right now you might not necessarily see sort of the intelligence and the design. I am on the billofrightsinstitute.org. I have given you this link, or I will be giving you this link with the video, and I want to review the actual text as well as the sort of meaning of the Bill of Rights, which is the first 10 amendments to the Constitution. The First Amendment. Now remember, there's always significance or persuasion to an order. So like no one held a musket to their heads and said you have to put it in this order. This was the chosen order. This was what they valued. So first up, Amendment number 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, of the press, of the right of the people peaceably to assemble, and to petition the government for a redress of grievances. That's number 1. Now, it makes perfect sense to me that in a land of Puritan exiles, the Puritans are gone by the time we're writing the Bill of Rights. However, you have religions like the Quakers and everyone else chock full in new colonial America. And again, they're not necessarily in agreement with the Anglican Church. It was incredibly important to each of the religions that they be allowed to worship there. In many places, there's more or less state-dictated religion. In England, you technically had to follow Anglicanism. It was up to the sort of opinion of the current standing king or queen how much they wanted to enforce that. So you might have just been lucky and some of them didn't enforce it very strongly. But oftentimes they did. One thing I told you about in a previous video was the execution of the Protestants by Mary I or Bloody Mary. So they're obviously afraid of things like that. Makes sense that freedom of religion continues to be something that is often debated about in America. One thing that it doesn't specifically state here, but is stated in other places, is that religion was meant to be totally separate from our statehood. That when you made laws, they were not necessarily meant to be religiously based. And that's because in the First Amendment, there is no established state religion. So you're not meant to make laws that inherently favor one religion. The laws are supposed to be divorced from that. However, it's kind of challenging because most religions inevitably make moral standpoints on various topics, and laws eventually have to draw a line. So does religion. Sometimes those lines get crossed. The other things, importantly, in the First Amendment are speech, press, peaceful assembly, and petition of the government. You guys are probably, I've noticed in your Do Now responses, already talking a lot about peaceful assembly. Whether or not peaceful assembly is effective or whether we're ignoring peaceful assembly in terms of more volatile, violent assembly and maybe what the purpose is behind that. Which is an age-old question. I mean, clearly Americans wanted the right to peacefully assemble, but we also violently revolted. There's a complicated history in America between the line of peace and volatility, forgetting what we want. In America, the freedom of speech and freedom of the press are incredibly important. Now, to put in perspective what that means, in England, it was illegal to write against the king. So if you were caught with any sort of writing or even talking, if you were overheard bad-mouthing the king, you could be sent to prison. Now you might be thinking this is like old, stale goings-on in long time ago England. There is still very much fear in other places of the world that you do not have the true freedom to criticize your government, that the press is not really free. You've heard of things like state-run media coming out of places like North Korea or highly controlled places like Russia, where it just so happens conveniently that any journalist who criticizes Putin happens to have an allergic reaction to poison in the months following their criticism. Happens. We are a country that allows you to have opinions against the government without being thrown in prison for them. In other countries, your ability to go or not go to prison can often come down to someone trying to determine whether or not you're joking or whether or not you're serious. For example, in a country of which I did try to look up, my internet's on the fritz right now, and I was trying to get this video done before the internet completely died on me. Some journalist put up a mocking picture of their prime minister, comparing them to the Lord of the Rings creature Gollum, and they were almost thrown in prison. They then had to make an about face and try to make the argument that the creature Gollum was actually the hero of Lord of the Rings. If you know anything about Lord of the Rings, you know this is not true. But the idea being that to make fun of his prime minister or king and compare them to Gollum nearly got him thrown in prison. Not a nice prison, not like a slap on the wrist, you bought your child's way into college prison, but like an actual, you're probably not coming back out prison. He eventually, it was found to be that he made a joke and he was allowed to go. Let's say that he didn't exactly stick around and see what else was coming out of this. First Amendment has several freedoms in it. It's important to remember that they all work together. It's also important to remember, frequently the thing I have to go over with freedom of speech, you do have the right to say what you will, but there are certain limits on it. You are not allowed to shout fire in a theater. That's an old example, but in other words, you are not protected by the First Amendment when you cause panic or incite riot. You're not allowed to threaten. I mean, if you do, you are allowed to have the consequences of it. You are allowed to criticize people. You are allowed to express contrary points of view. You're allowed to express unpopular points of view. But causing chaos or violence or directly threatening violence are not protected actions under the First Amendment. Amendment 2. This one often, every year, at least one of you will write about gun control. Amendment 2. And I think here, if you have not heard the phrasing of the Second Amendment in quite a while, it really bears listening to. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. You guys know the second half of that like the back of your hands. The right of the people to keep and bear arms shall not be infringed. But the first half we often don't talk about. A well-regulated militia being necessary to the security of a free state. So what does that mean? It means that the colonies had no standing army because the colonies were technically underneath and owned by England. The army was the British army. They were the ones we were fighting. Now, you didn't leave a standing army here in times of peace. When the standing army gets left here, that is a not so subtle declaration that we are at war or soon to be at war. That's an aggressive move. Like if you guys were to go to ShopRite and you were to see tanks on the street, you would kind of understand that this isn't like a polite assist from the government. You know, this is war times. A well-regulated militia would mean that in, say, a community like Tinton Falls or Eatontown, these are small towns, you don't have a standing army here. If you needed to, say, rally the people to fight an Indian raid or to protect the from bears or the French, who we didn't always get along with, then we were besties with, then we didn't get along with again, it's a long, complicated history. You would need to rally all the local guys, and they would need to take all their own weapons, and they would form the militia. So the militia is sort of like your local police force. And obviously you're not being assigned weapons from the government. So like the King of England's not shipping out a bunch of muskets to Tinton Falls and Eatontown and saying, hand them out to everyone and arm yourselves. You were in charge of protecting yourselves. And I mean, on a very basic level, if you had a local skirmish, if a fight broke out, if there was a bear or a pack of wolves that were dangerous to your community, you guys were on your own. One of the things that became kind of dangerous was that when England was trying to limit us, it became obvious that if they took our weapons, we would have nothing. We would be sitting ducks. So it became something we had to fight for, the ability to arm and protect ourselves. And it gets kind of conflated with the language from the Declaration of Independence, where it's like, it is our right, it is our duty to stand up to government we find to be corrupt, and that it's almost like we have to arm ourselves to do that. This is definitely one of the ones that people continue to have an argument about, whether or not it should stay, whether or not we should have an amendment that sort of backs this one out, whether or not this amendment has aged poorly. We certainly live under vastly different conditions. There are other amendments that you will see kind of age out, right? They don't have the same historical significance now as they did then, and we sort of just ignore them and leave them there, and no one's concerned about making sure that those amendments are upheld. But this one we continue to argue about. I will say I have read really great research papers on both sides of the aisle for gun control, and I learned an awful lot both sides, I should say. So either way you swing with it, you will find that it's actually a really fascinating topic. Amendment 3, no soldier shall, in time of peace, be quarantined in 2020, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. This is the one that, like, does anyone lose sleep over reading this and worry that suddenly soldiers are going to knock on your door and try to sleep in your house? The problem was that you didn't have, obviously, established barracks for soldiers everywhere in the colonies. So during peace or during wartime, the British Army could knock on your door and force you to house and feed its soldiers. I'm just going to say that this didn't always go well. Either we didn't agree with the soldiers and their political standpoints, or the soldiers weren't nice. I mean, sometimes it was fine, but like occasionally this led to more violence. So the Americans wanted to protect themselves by saying, no one will force you to open your door to our soldiers. Like, we're going to make sure there are other places. If you want to open your door, go right ahead, but we're not going to compel you to. Amendment 4. The right of the people to be secure in their person, house, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So, prior to this, say you were a rabble-rouser in the colonial era, and the king's men knew that you likely, in your house, had some sort of paper or letters criticizing the king. As I stated earlier, that was illegal. So if they found it, they could arrest you. They could also just have it in their pocket, knowing that they could put it in your house and everyone would believe that it's yours. So they used to just burst into people's houses, ransack everything in their house, looking for something that they could use as evidence against people. And they would find it. But like, that's not okay. You should be allowed to have private papers in your own house that express points of view. That should be totally legal. But this was something that we needed to establish in our own country was not fair behavior for the government to do. And particularly here, probable cause. Probable cause continues to be an issue particularly recently. In the last 6 months, I don't think I've ever heard quite so much conversation about the phrase probable cause. Probable cause has taken over part of the discussion about protesting, as well as police rights, as well as citizen rights, and whether or not probable cause is being properly upheld. So if you were wondering about a research paper topic, there's something there. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia where in actual service in times of war or public danger. Essentially, you need real charges against you, and if you are part of the military, you're on your own kind of scale of justice. The military has its own tribunal to deal with things like that. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. So you have to have charges put against you that go through the process, right? That go through the hearing of a grand jury and stuff, and you can't be charged for the same crime twice. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So, there's a lot in here. Double jeopardy is a big one. You cannot be charged with the same crime twice. So, if you look up the Amanda Knox situation, Amanda Knox was an American student who went to study abroad in Italy. Her roommate died. Amanda was charged with her murder. She was found not guilty in Italy after years and years, and then she was pressed with murder charges again, because not everyone protects you from being charged with the same crime twice. Say you are charged with murder here. A notable case would be like the Caylee Anthony murder. This little girl went missing. I don't know about you guys, but if my 2-year-old went missing, I would not wait a month to report her missing. Just saying. And then this woman seems to have known that the daughter was missing all this time, but waits a month to report her missing. There's a lot of suspicious behavior, but nothing illegal. They eventually find the child's body. The child's been dead this whole time, but the body was so degraded that they couldn't determine much in terms of cause of death or when it happened or how it happened or who was responsible. The mother was charged with murder, but due to, just sheer lack of evidence, she was let go. She can never be charged with that crime again. Doesn't matter if one day we reinvent the wheel and we can suddenly reprocess all this evidence and determine that she actually is guilty. She has been found innocent, so she can never be recharged. That's Amendment 5 at its finest. The other thing is, you've heard people say, I plead the fifth. So if you are going to say something that potentially incriminates you, you have the ability to say, I am pleading the fifth. Like, essentially, I refuse to open my mouth and answer your questions on the grounds that I might accidentally say something that gets me in trouble. You are protected. You're allowed to say that. You should never answer questions put in front of you without kind of understanding what your answers could do to you. And also, your property cannot be taken from you without being compensated. I mentioned in Salem, like, if you were found guilty, all of your property went to the state. We can't do that here. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right of a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. This is a big one. You have the right to a lawyer. You have the right to a speedy trial. We can't just keep you in jail for 50 years awaiting your trial. Your trial should be in the place where you got in trouble, so you're not going to commit a crime in Kansas and go to a trial in New York. That's not going to happen. You have the right to see your accusers. If someone's accusing you of a crime, you have a right to see them, and you have a right to get witnesses on your side. These are not things that were protected before this. I explained how courtrooms looked in Salem. This is how it looked for a long time. Many people did not have the right to counsel. You have a right to someone representing you so that you have a chance to protect yourself. Amendment 7. In suits against common law where the value in controversy shall exceed $20, The right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the U.S. than according to the rules of the common law. So, like, you have a right to essentially go to court to, fix your problems, and once, you get an answer, that's it. You have the right to that answer. I mean, you can appeal it to higher courts, but you can't put it through the same court twice. Like if in local court you lose a case, you don't get to go, well, we're going to the local court and trying again. You already lost your case. You can appeal it to a higher court, but you could take something all the way to the Supreme Court if you wanted, but you can't kind of retry in the same area. Amendment 8, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So we can't do things like, if your bail, for you guys as sort of minors, your bail would be figured on your parents' income. So if you did a really bad thing and you went to prison and we had to bail you out, they couldn't just say you have a $50 million bail put on you. They would kind of, by the level of crime and the level of income, determine what something fair would be. Excessive fines, we can't just put fines on you until you're so broke you can't do anything. And cruel and unusual punishments. We can't do things like torture you. Cruel and unusual punishments frequently, I guess not frequently, it just feels like that now. That's an interesting phrase as well, because what is defined as cruel and unusual evolves over time. And whose fault and responsibility it is also kind of evolves and changes. The next one. We are on 9, and then there is 10, and then we are done. 9, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Essentially, if we haven't listed something, that doesn't mean that, it's formally denied or formally allowed. So we know that 10 is not enough amendments. We'll get back to it. Very smart of the founders. And Amendment 10, the powers not delegated to the U.S. by the Constitution nor prohibited by it to the states or reserved to the states respectively or to the people. So this is important. If the federal government does not say, we have a law pertaining to this, it is the job of the states to decide it. Now, in many instances, things like abortion, things like gun control, they are meant to go to the states, not to the federal government. So if you were wondering, especially given the death of Ruth Bader Ginsburg, many people are now arguing whether or not Roe v. Wade is going to come back into the Supreme Court for review. One of the big question marks about Roe v. Wade is, should the federal government have rulings over this, or should it be left up to the states to decide? As with many things, we usually allow states to decide rather than have the federal government put an overall ruling on it. I think students who go over the different healthcare rights, especially ones associated with things like abortion, find that this is where Amendment 1 and Amendment 10 start to butt heads. Which one is more important? Which one is the one at play? Which one are people more concerned with? These 10 amendments, the core original Bill of Rights, do make appearances frequently on research paper, and for that, and kind of understanding where people come from, some people find some of them more important than others. Some people think that 10 is the most important one. Others don't. I want you guys to review this just because it could come up as essential for you in research paper. Catch you guys on the flip side.